Thank you. Good evening, everybody. My name's Alexander Uff. I'm a barrister at Quadrant Chambers, where I specialize in international commercial and investment treaty arbitration. My topic tonight is an arbitration topic. It is, what is the separability principle? And I'm going to start here. Now, arbitration is a form of dispute resolution where jurisdiction is based on consent. That's to say the parties have to have agreed to submit their dispute to arbitration. And that arbitration agreement is normally located in the party's contract. So, what happens if, for example, that contract is invalid or never came into existence? Now, as a matter of simple logic, if the contract doesn't exist, then neither can the arbitration agreement contained in it, right? No, but applying logic creates a risk of undermining the effectiveness of arbitration. For instance, if the arbitrators decide that the contract is invalid, then it would follow logically that they also had no jurisdiction to decide that the contract is invalid in the first place. But equally, it also means that a party can derail or frustrate an arbitration or create grounds for annulment simply by alleging that the contract is invalid or illegal. And that brings us to the separability principle. So when we speak of separability of an arbitration agreement, this is a bit of a mouthful, but it refers to a substantive rule that the invalidity or non-existence of a contract does not necessarily entail the invalidity or inexistence of an arbitration agreement contained within that contract. Instead, the existence and validity of an arbitration agreement is to be assessed independently of the contract to which it relates. So, the separability principle developed as a pragmatic solution to the logical conundrum we've just seen. Now, separability sits side by side with the procedural principle of competence. That is, that the arbitral tribunal has power to decide on its own jurisdiction, and to do so first, even if not definitively. And these rules operate to prevent parties from sabotaging an arbitration by simply alleging that the contract is invalid or inexistent. And equally, alleging the contract is invalid will not alone create a ground to review the award or resist enforcement on the basis of a lack of jurisdiction. So it really, rounding that up, separability is one of a small handful of rules that is necessary to ensure that the system of international arbitration operates as a robust and effective means of dispute resolution. Now, going to its origin and development, separability was first articulated to its full extent in English law in Harbour Assurance versus Cancer in 1993. Now, Harbour concerned a reinsurance contract, and the allegation was that the contract was void for illegality because the reinsurer was not authorized to conduct insurance business. And the Court of Appeal, looking at that, affirmed that the alleged illegality does not affect the validity of the arbitration clause. But separability actually has a much longer lineage than that. It was established in French law by the Cour de Cassation in the Gosset case in 1963. Gosset was the losing party in an arbitration in Italy and tried to oppose enforcement in France by alleging that the contract was invalid and that this entailed the invalidity of the arbitration agreement contained in it. The Cour de Cassation was having none of it. Their response was to describe the arbitration agreement as having full legal autonomy and therefore that it was not affected by alleged illegality of the underlying contract. But we also find the notion earlier in English law. An arbitration agreement was found to survive an accepted repudiation of a contract in which it was located as early as Hayman and Darwin's in 1942. The separability principle is also codified in English law and many other legal systems. In English law, it's found in Section 7 of the Arbitration Act, and that's no exception. It forms part of the model law and most advanced legal systems. And equally, separability is now enshrined in the major sets of arbitration rules, in usually similar terms and often linked again to competence. How far does the separability principle go? Now, when I gave you a definition of separability, I said that the invalidity of the main contract doesn't necessarily entail the invalidity of the arbitration agreement. Now, separability doesn't immunize arbitration agreements against any allegation of invalidity. The rule is that validity or invalidity falls to be assessed independently for the arbitration agreement and the overall contract. So how does that play out? Now, when you think about these cases, it's useful to go back to Heyman and Darwin's and Harbour Assurance, both of which speak of treating the arbitration agreement as a collateral contract to the main contract. Now, it's worth saying that that analysis isn't uniformly adopted. The English Arbitration Act and the arbitration rules which speak of this are agnostic about the collateral contract analysis, and they're all careful to say that the arbitration is to be treated as a separate agreement for that purpose of assessing its validity, but not for all purposes. Nonetheless, thinking about allegations of invalidity and so forth, it is helpful to ask yourself whether the allegation would affect the invalidity of the main contract and whether it would in addition affect the parties' consent to arbitration or not. If the allegation were, for example, forgery, that there was never any consent to the contract at all, it's fairly obvious that in that circumstance the consent goes not only to the overall contract but also to the arbitration agreement within it. Both are directly impeached. But let's take some more examples. If the allegation is that the contract is discharged by frustration, or assume that a buyer invokes a right to rescind a contract for misrepresentation by the seller, in either of those cases, if we imagine a freestanding arbitration agreement, hypothetically, does the ground for invalidity prevent the parties from agreeing to arbitration? Obviously not. And what about fraud? Now, the well-known Fiona Trust case concerned 8 charter parties which were alleged to have been procured as a result of bribery. And the question that came before the House of Lords was whether it is possible for a party to be bound by submission to arbitration when he alleges that but for the bribery, he would never have entered the contract containing the arbitration clause. And the House of Lords answered that question with an affirmative yes, adopting the reasoning that enshrines its famous one-stop presumption, that parties wouldn't rationally wish to agree separate dispute resolution mechanisms for different issues. And as Lord Hope put it, the doctrine of separability requires direct impeachment of the arbitration agreement before it can be set aside. The argument must be based on facts which are specific to the arbitration agreement and allegations which are parasitical on the challenge to the validity of the main contract will not do so. And that is my talk on the separability principle. Thank you very much.